Please note that this content is for adults only. Viewer discretion advised. If you haven't yet, hit the subscribe, like, and share. Hello everyone and welcome back to another live stream with me, Xana K. This is Grizzly True Crime, and if you are brand new here, I am South African, living in the Netherlands, otherwise known as Holland, with Mr. Grizzly, who's Swiss and Fury. So today we will be looking at the Idaho case. If you don't know anything about this case, I would highly recommend checking out the playlist, which is linked below for you. 4 University of Idaho students were brutally murdered on November 13th of 2022. Maddie Mogen, Kaylee Goncalves, Ethan Chapin, and Xana Kernodle. And a suspect was arrested within 49 days, and that suspect is Bryan C. Kohberger. Now, there's been a lot of document time, a lot of deep dives and everything, especially since his arrest. There's been so many documents, okay? And we've got more to go over today. And yesterday, there was actually a scheduling conference that the defense asked for, and that changed everything. So here we thought that the trial was going to take place on October 2nd. You know, we didn't believe it, and then we were like, oh, okay, after the last hearing, they're like, nope, it's definitely going to happen. Well, now it isn't. It is not happening. So if you missed that news, if you didn't see the community tab, or you haven't seen any other breaking news anywhere else, yes, the trial will no longer be starting on October 2nd. We don't know exactly when it will be happening. Welcome to all my moderators. Thank you so much for everything you do, and thank you for welcoming everyone as well. Welcome to all my patrons. I hope that you enjoyed my little snarky waffle time I posted for you today. Welcome to all my members as well, and all the new members that'll join today. All the original subscribers, everyone that's going to subscribe today, really appreciate you being here. If you would just take a second to please like and share so that others know we are live as well, and they can come and join us here as we watch this status conference together, I would much appreciate that. Okay, so let me just make sure I get the chat ready for us here on screen, and then we can dive into it. I have done my very best with that audio. Oh my word. Wow. Like, in the courtroom, for some reason they put the cameras right where the court reporter was. So you hear a lot of typing, and I tried so hard to reduce it as much as possible. If you don't know, I've recorded some audiobooks before, right? Up to audible standards. That was hard. So I know how to take out background sounds and typing and things. And this was really difficult because the camera was right there by the court reporter. So anyway, I couldn't actually get rid of a lot of it, but we'll do our best with it. Quirky Carlotta, member for 4 months. Thank you so much. And you say, thank you for all the great content. Thank you very much. Really appreciate it. All right. So what I'm going to do now is the first thing I want to show you is the status conference, right? So I'm going to put it like this. Okay. Like this. And as you can see from the top, you might have a hint. I have uploaded this for those that are pressed for time and they just want to watch it later without my commentary. You can. Okay. We make sure that everybody's happy. Danny Scale says, how can they demolish the house before a completed trial? Well, they've given reasons for that. Thank you so much, Danny. They say that it's been so cleaned and everything inside now, it's all different. So they're saying it wouldn't benefit the jury. But I mean, I know that many of us disagree, right? Many of us are like, what? So this is the scheduling conference that took place yesterday. And basically what happened was that Bryan Kohberger waived his right to a speedy trial. Now, what that means is in America, every suspect, every person charged has the right to a speedy trial. And that would mean that within 6 months from when he's arraigned, there's going to be a trial date set. There should be a trial. Now, he waived his right to do so, which means they need more time to prepare for the trial. Of course, that means that this could take a long time before we actually see the trial happen. You know, is it going to be 6 months, a year, 2 years, 5 years? We just don't know. Now, it's what we usually see in true crime, which one would think, because this is a death penalty case. Bryan Kohberger has the right to a fair trial, and him and his team have decided it's just way too quick. I mean, it would have happened in something like, I think now, from when I last counted, it should be like 39 days from now or something, is when it was going to happen, and now it's not going to. Sarah says, I've been a member long enough to have a baby. Oh, man. Okay, thank you so much. Karen Says, my heart breaks for the families and survivors. They haven't, yesterday on the Goncalves family page, before the hearing started, they said, please pray for our family today. And I haven't seen them post anything since. So this must be incredibly heartbreaking and frustrating for them. Karen says it must be emotional and mental torture. I can't imagine the hell that they are in right now. Right? Whew, it's going to be a long, long road to justice. Okay. So I'm going to play you the status conference, starting right here. If I need to boost it, please let me know. It should be fine though, because I have already boosted it in my software. So I hope it's good. And as I say, sorry, I can't actually take out all the typing. So that's on the court. Okay, so the defense requested a status conference. Let's go.
The defense, Ms. Taylor, requests a status conference for today. So here we are. Go ahead.
Thank you, Your Honor. Your Honor, we asked for this status conference today because I have had some opportunity to meet with Mr. Kohberger and talk about his trial date and his speedy trial right. Your Honor, we're here today to ask the court to continue the trial setting, and Mr. Kohberger is prepared to waive his right to a speedy trial.
So in this live stream, I'm going to be pausing and going to be making commentary. Let me know how the sound is. I hope it's okay. Tell me if I need to boost it some more. But basically what was just said was that Mr. Kohberger is prepared to waive his right to a speedy trial. That's what was just said there, okay?
Your Honor, there are a couple of things that I need to place on the record. One can come after the court takes his waiver, but one I think ought to come before the court takes his waiver. Your Honor, as the court knows, we will file a number of motions to strike the death penalty in Idaho's scheme of capital punishment. Because we're here today to waive speedy and ask the court to continue, I think the court and counsel ought to know that one of the motions that we will be filing is a motion to strike the death penalty because it could.
If you didn't hear that, they're going to be filing a motion to strike the death penalty, okay? And here's the reason.
Places Mr. Kohberger in a position where he has to choose between two rights. One, that being the right of the speedy trial, or the other right to effective assistance of counsel. I didn't want that to come filed later and have it be any surprise that I knew it was coming. It will be.
So they will be filing a motion to strike the death penalty. Why? Because Kohberger has to choose between the right to a speedy trial or the right to effective counsel is what they said. And so that could also, imagine, they're going to file that motion. Imagine if the judge actually grants it, then death penalty will be off the table. And then things will take a long time, by the sounds of it, to get to trial. Okay, love, light, and ASMR. Make sure you use something that's in both ears because I can only hear it in my left ear sometimes. That's the other problem with this court audio, the court feed. It was just in one ear and then later it was dual and then later it went back to just the one. So yes, it's not the greatest quality all over the place.
That motion will be coming. And for us to stand up and request a continuance and waive speedy today. The rest can be placed on the record after the court's questions.
Well, you heard all that, Mr. Kohberger? Yes?
Yes.
And is that the case that you want to waive your speedy trial rights?
Yes.
And do you understand that those rights are statutory in Idaho, also protected by the United States Constitution and the Idaho Constitution?
Yes.
You understand that if you waive, you're waiving really forever in this case. So if we were to push this out, this case, and then something else happens that allows us or requires us to push it out a little farther, you can't claim your right to a speedy trial at that point. You understand that?
Yes.
So have you had enough time to discuss this with Ms. Taylor?
I have.
Is anybody?
So I hope you caught all that. He's like, Okay, just so that you know, if you're waiving your right to a speedy trial, this is what it means. You know, you can't later change your mind. And he says he understands completely. So now the judge asks, is anybody pressuring you to waive your speedy trial rights? He says no, so let's have a look.
Pressuring you to waive your speedy trial rights?
No.
Sure you want to do this?
Absolutely.
Okay. You agree with this?
So you heard that. Are you sure you want to do this? And he said, absolutely. Like, he's not just like, yeah, I think so. He's like, absolutely. This is what the defense is going with now. Waiving the right to a speedy trial. So, yeah, the trial is no longer taking place on October 2nd. It's not starting on October 2nd of 2023. Okay.
Ms. Taylor?
Your Honor, I do agree with this. I do not believe counsel can be effective by October 2nd, the entire phase, if we should end up in a part 2 of this trial. Our investigation is not complete. Our work with experts is not complete. We haven't completed our review of the state's evidence. I do not believe that we can be effective by October 2nd.
Thank you. Is Mr. Kohberger willing today to write, sign his name and agree to sign your name on a waiver of speedy trial?
Your Honor, I can tell you that I did not prepare Mr. Kohberger for that, and that would be because I am not familiar with this court's practice. I expected we would waive in open court today, and that would be sufficient. I'm happy to take a look at the court wants us to look at it.
Well, I wasn't really anticipating this.
Yeah, so the judge says he wasn't really anticipating this, but basically the judge just asked, so, okay, you're going to waive your right to a speedy trial. Are you willing to fill in the forms today? Can you sign it now? And he actually did, and we will look at those documents right after this as well. So, yes, and the judge says, yeah, I wasn't really anticipating this. So he's got a form there for them, and he's talking about that now, and then he's going to hand it over to them, and then they're going to sign it. Okay? So here we go.
But just in case, and hypothetically, I grabbed a Odyssey form, which I don't really favor those forms, but I did pull that out, and maybe I could give this to you, Mr. Kohberger, and we could take a look at it. My practice is always to get a written signature of waiver in any waiver of speedy trial. So let me go to, and I haven't taken its way.
Okay, so now they're going to hand the form over and they're going to sign it, and we can look at that right after this. Archive gig footage. SJ cases, will the gag order remain if the delay goes on for years? I would like to see that as well. I don't know. I just want to remind you guys that I'm not a lawyer. I do not have like legal expertise. I'm just like you, unless you're a lawyer. There are some lawyers in chat too. So certain questions like, you know, Vanessa was saying, why is the death penalty off the table now? Well, I did give the reasons that they gave in court. I put it on the screen. Those are the reasons. He has the right to choose between a speedy trial, to waive his right to a speedy trial, or for effective counsel. Those were the two reasons they gave. There's a lot of law tubers, like the lawyer you know, that you could watch. He just did a stream now, okay, to explain more in depth of the legal stuff. We're here to watch it together as if we're watching a trial together, right? And to discuss what we know and what's going to happen and what can we expect next as the public. I think here at Grizzly True Crime, we represent the international public, and we're just watching and going like, what is going on here, right? Okay, so to continue on, the form is going to be passed now, and now they're going to sign it.
Waiver yet. I'm going to notice that, but I just want to let that settle for a second. Mr. Thompson, do you have any objections?
No, Your Honor. I mean, I think everybody would like to have this resolved sooner than later, but I think the case is of such great importance and complexity that this is a smart move.
Thank you.
For for anyone just joining now, because there are some people that have just joined now, I'm making some commentary on the scheduling conference from yesterday. Number two, the audio is really, really crap from the court feed, and that is what they provided to everyone from the court cameras, right? And what I did with it was boost it as much as possible and try my level best to get that typing sound as low as possible, okay? But it's very hard because the camera was obviously placed right there. So if you at all feel like, what is up with this audio? Go listen to the raw footage. It's much worse, okay? So we're doing our best over here.
I do agree with that. I mean, we have so many things going on. There's a lot of issues left to resolve. And as you know, I mean, you probably could understand that. And you were all thinking this, that it's going to be very difficult to put everything together that needs to be put together before October 2nd. This is a very significant, complicated case for all the lawyers, and particularly for Mr. Kohberger.
Okay, so the judge said this is a very significant, complicated case for all the lawyers and particularly for Mr. Kohberger. Just to clarify, with everybody freaking out, is the death penalty now off the table? No, it's not off the table. It's still a death penalty trial. We don't know when the trial will be. The next court date's September 1st. We're going to get to that. And thirdly, Ann Taylor, Bryan Kohberger's defense attorney, said she's going to file a motion to strike the death penalty, right? So there will be a motion filed. Then we'll have to see, will the judge grant that or deny it? But at the moment, it's still very much on the table, okay? Just to make sure that you'll understand, it's not off the table yet, so don't freak out.
I understand you want to be fully prepared for the trial, and if it happens, also so, and likewise for the state, likewise for the court. I mean, I was willing to do that, but you don't want to, you have to. I mean, any of these issues, because they're all important. So, I don't know, I think you can take a look at that form.
Maybe have just a moment.
Yeah, go ahead.
Okay, so they're looking through the form, and now they're going to sign the form to waive his right to a speedy trial. Okay. Now they both signed it. Now I quickly want to show you something. Okay, just hold on 1 second. Let's quickly go here so that you can see it for yourself. And while we do that, let me show you something quickly as well. I'm just going to show you the document that they just signed. So just hang in there. Document time. Thank you so much to Van for making that art that I showed at the end there. So let me just quickly show you this one document here, which as you could see it, I'll just have to resize when I go back to the other one. Just hold on 1 second. This is what they just signed. What you saw them there looking at and signing, here it is. So now you can see Kohberger's signature and everything as well. They say here the defendant. Okay, so State of Idaho plaintiff versus Bryan C. Kohberger, defendant. The defendant acknowledges that the defendant has a right to have this case brought to trial within 6 months of the defendant's arraignment in district court on an indictment or within 6 months of the filing of the information. Further, the defendant acknowledges consulting with the defendant's attorney regarding the right to a speedy trial pursuant to the 6th Amendment of the United States Constitution, Article 1, Section 13 of the Idaho Constitution and Idaho Code Section 193501. Based upon careful consideration and consultation with the attorney, the defendant waives the defendant's right to a speedy trial. The defendant fully understands the advantages and disadvantages of waiving the right to a speedy trial and believes that it would be in the defendant's best interest to give up this right. The defendant further understands that once the right to a speedy trial is waived, the court may set this case for trial more than 6 months from the time in which the defendant was arraigned in district court on an indictment or from the filing of the information. So that's from signed on the 23rd of August of 2023, which is the day that it happened. You saw the moment it happened, and there you could see the defendant's signature as well as the attorney for the defendants. I like her signature a lot, right? Okay. And it says, wow, his signature's big. Let's see what Caroline says, and then we're going to go back to that scheduling hearing. Caroline says, my opinion so far is the defense attorneys want to make themselves famous, and BK is only too happy to go along with it since he thinks he's special but unrecognized by society, seems to me. Damn, well, you never know, you never know. Okay, so now to go back to what we're watching here, that's what you just saw them sign. Okay, so we're going to go back to continuing on with this scheduling hearing. So here we go, and if you're only joining now, I hope you'll watch from the beginning, and don't worry if you press for time and you don't have time for all this commentary, I'm going to upload a clean copy for you as well. Okay, so let's listen on.
Thank you. So, Mr. Kohberger, did you read this over?
Yes.
Okay, what I'm talking about is the written waiver of speedy trial.
Yes.
Did you understand the terms here,
Yes.
which we've already talked about?
Yes.
And you agree with the signing of the form waiver of speedy trial, Ms. Taylor?
I do not.
Okay, so Mr. Kohberger, do you want me to accept your waiver?
Yes, I do.
Okay, and you understand that if I accept your waiver, you're giving up your constitutional right under the United States Constitution and the Idaho Constitution on a constitutional right of speedy trial?
I understand.
Do you understand that if I accept your waiver, you're also giving up your Idaho statutory right to a speedy trial?
Yes.
That is within 6 months of your arraignment.
Yes.
And you agree with the tender of the waiver, Ms. Taylor?
I do not.
Kohberger, do you want me to accept your waiver?
I do.
Based on our discussion, your waiver of these rights expressly in court and also in signing this waiver of speedy trial. Also, you are tendering these waivers on advice of counsel. I will accept your waiver of speedy trial. I find that your waivers are knowing, intelligent, and voluntary, and there's actually good cause to recognize that. Given what I heard from your counsel, Thompson, and my clients. So, with that, we can talk about resetting this trial. I'm prepared to do that today. Sarah?
Your Honor, I would say that we are not prepared to choose.
Okay, let's just pause for a moment. The judge said with that, we can talk about resetting this trial. Are you prepared to do that today? Now, the defense is saying they're not prepared to do that today. They can't set a date today. They first all want to tackle what's happening on September 1st. So remember in the last episode, we went over they had a scheduling motion. There were actually 6 motions that were meant to be argued on in that last long hearing, okay? And I think only 4 out of the 6 were actually argued that day. Remember, it was all about the DNA and all that. Okay, so we went over that in depth. I did a whole deep dive with you in a presentation of what that all meant. Then, remember, they set all those deadlines. There was a whole page of dates and deadlines. Well, that's all out now, except for September 1st. So the trial date gone and all the other dates leading up to that. All those hearings gone, except for September 1st. That they're keeping, and they're going to be discussing, the next steps, really, at that hearing, and all the motions that they're going to be filing and all that kind of stuff. So, yes, that's what's happening, and that's what you're going to hear now when the judge said, are you prepared to do that today? So here we go.
That brings me to kind of the second part of what I wanted to talk to the court and counsel about today. We currently have September 1st as the date for the motion to dismiss the grand jury indictment. Our deadline to file our challenges will be today, and we're prepared to file those today. Our hope is that that particular hearing date, we'd like to keep it, both challenge the grand jury indictment, and also there are 2 additional motions that we're going to be filing, and we're hoping that we can have those heard. After that time, after we've heard the motions, we'd be in a position to meet with the state if we desire and talk about a reasonable trial setting.
Okay, now pay attention, because I'm going to put on screen exactly which 2 motions they want to file as well. They already said they want to file a motion to strike the death penalty, right? A motion. It doesn't mean it's off the table. Filing a motion. And now they're going to talk about 2 other motions that they do want to file, okay? So somebody asked a question that I wanted to answer. I can't remember what it is now. Sorry about that. Oh, you were asking if the trial will start in 6 months from now. No, the speedy trial would be for 6 months. A speedy trial is within 6 months of when the person was arraigned. So now that he's waived his right to a speedy trial, now they don't have to have it within the 6 months from when he was arraigned, which I think the original date, if you look at from when he was arraigned plus 6 months, would have been like November 22nd, I think it was. But then they set the trial for October 2nd to November 17th. So they had lots of time beforehand to make sure they don't like leave it till last minute. But now the trial's not starting on that date. Okay, so now let's have a listen to the 2 motions that they want to file. Okay, one of them is about cameras in the courtroom, which I know some people are not happy about. I know we want to see, but really, it's got to be a fair trial. They got to do whatever they got to do. You know, I know that's a very contentious topic, whether they have cameras or not. We'll see what happens, but that will be one of the motions to media related. Maybe not have cameras in the courtroom, and then it would be like Lori Vallow Daybell with audio only, no matter what it is. No matter what it is, guys. I don't care if they give us sketches, audio, tweets, or whatever they're called now. You know, it doesn't matter. We'll be covering it whenever it happens. So don't worry about that. Okay?
Preference would be to have us discuss that and reset the trial one time and not do this a number of times and worry about getting subpoenas out and worry about that would be my request. The other deadlines that are in place right now on the court's scheduling order, I think those would be appropriate for us to talk about and the state and the defense and perhaps suggest for the court to order a different scheduling order than the one that exists. We just simply want to keep the grand jury indictment challenge date because that's soon, and having the court's decision on that will largely impact what comes next. If the court will allow, I'd like to briefly address the other 2 motions that are coming and have not been filed today.
Sure.
Okay. Your Honor, we will be filing a motion that has to do with media in the courtroom, particularly the cameras in the courtroom. And that motion should be filed by the end of the day or first thing tomorrow. That comes from some things that happened last week when we were. The other motion, Your Honor, has to do with what happens to witnesses that the defense might.
Okay, to break it down for you. The 2 motions that they're going to be filing is one, a motion that has to do with media in the courtroom, which we can just translate that as, cameras. Or maybe it's also about zooming into Kohberger, which they've never stopped doing, not for one day. You know, so yes, there's that. They might just say, fine, there could be cameras, 1 camera, but you got to face forward. You can't look at Kohberger, whatever it is. It could be that, right? Angie Binaman, thank you so much. I really appreciate it. And the second motion that they want to file is about what happens to witnesses after they testify. And now Ann Taylor is going to explain that when Gabriela Vargas, one of the genetic genealogists, testified, when she went home, she was approached by 2 FBI agents that then questioned her about things. Later, in the same hearing, you will see Bill Thompson, the prosecutor, actually explain why that happened. So that's what you can listen out for. Now, if you're just joining now, yes, there's a lot of typing sounds. It's the court's cameras. The court camera's problem. We did our best to limit that, boost the sound. This is the best audio you can get right now out there, even though it's still pretty crappy, okay? But thank you for being here to watch it with us.
The court will recall Gabriela Vargas testified last Friday in our hearing. Last night she was by 2 FBI agents and interrogated about her testimony and the timing of her declaration. That, in our view, impacts Mr. Kohberger's due process rights and his rights to effective assistance of counsel, and that motion will also be filed later today at first thing.
Any objection to hearing the motion along with these 2 more motions to be heard on?
I put the closed captioning on because this is one of my videos I've uploaded for you for later, so you could just rewatch it in peace with now knowing what's happening here. Okay, and so you can see some of it is not. The audio is so bad that it gets some of the words wrong as well, but we'll do our best with it.
On September 1, Mr. Johnson?
I don't believe so, Your Honor, having not seen exactly what the motions are, but understanding they're fairly straightforward. I would think that we could, if we look at the motions and we have an issue with raise the support of Ms. Taylor. I will, for the record, since Ms. Taylor has brought up the situation, Ms. Vargas did court and counsel background. Over the weekend, Ms. Vargas, after she testified, engaged in some electronic communications with others in the genetic genealogy field. Those indicated, as it was reported to the investigators, to our investigators, that she was redating on some of the things that she testified to in court. When we heard of that, I reached out to the investigators and said, can we find out what's going on? And the FBI indeed undertook an investigation. And their reports are that Ms. Vargas claims that some of what was in her declaration, she inadvertently agreed to or signed without fully reading it. We're documenting that so we can expose it to Ms. Taylor and to the court, because I think it goes directly to what happened last week. That's the only reason that she was contacted, because it was reported to us that she was retracting some of what she had testified to and what was in her declaration. And we felt in fairness we needed to uncover that quickly. There was no other motive, no other motivation to this. I just wanted to thank the court.
Your Honor, that's certainly different than the information that I received. I would have been happy to be advised about that, but I'm not sure that's accurate. I'm sure that's what Mr. Thompson heard. I'm not saying they're calling him a liar, but the quality of the information he's received, I'm not sure that's entirely accurate. My hope is that these 2 FBI agents that were at Ms. Vargas' home last night, hopefully they reported everything that they talked to her about, and that should resolve the issue of last night.
Great. We'll hear about it at the hearing. That's how we sort these things out.
Yeah.
So back to a change of the scheduling order. I think it does make some sense to redo that. You want to just talk about that before we start taking that apart? We don't have to do it right now, I'm saying.
Judge, the state's position would be is that the court vacate the October trial date, vacate the scheduling order, let us get through what we're going to do on the 1st, and then let's talk and see if we can come to an agreement. If not, allow the court to set a date for trial as realistic, and then have a scheduling order generated that reflects the time preparing for trial and is useful for both parties related to.
Acceptable, Ms. Taylor?
Yes, Your Honor, I agree. We should get through the hearing on first, and then we're happy to meet with Mr. Thompson in his office and discuss an appropriate trial date.
That counsel can talk about some of those things before we're taking it back to the court.
Yes.
I fully support that. So I'm vacating the trial, October 2nd, and I'm vacating the scheduling order except for September 1st. Okay? So except with Mr. Kohberger's waivers, speedy trial. I have maybe a personal issue to discuss with you. First of all, I wanted to tell you I'm getting requests for excuses already from.
Okay, I'm just going to pause there for a second. I hope you heard everything there. So the judge is vacating the trial date and all the other dates, but keeping the September 1st one. So September 1st is the next court hearing for us to keep our eye on. That's what we need to know as the public. What's next? September 1st. Let's see what happens after that date. Then they're going to discuss what the next steps will be. But I'm sure there's going to be many motions. 3 were already brought up today, as in our coverage here. This happened yesterday, by the way, the scheduling conference. So 3 motions were brought up. That's going to be filed. They're going to have to be discussing that. There's going to be a lot of paperwork. Eventually, have you seen the Idaho cases of public interest site? It is so long. You got to scroll so much. There's so much going on in this case, and it's just going to get even longer now. It'll be years, I'm sure, of documents. My goodness. So Jellybean says it is what it is. Going to have to be patient, even though it's hard. Imagine how the family feels. Yeah, exactly. So send them lots of love and support. Okay, so now the judge is talking about, he said he wants to discuss something maybe a little more personal, and he said, I'm already getting excuses from potential jurors. And he's actually not going to allow those people to be excused. He's going to still, when that time comes, bring in that pool of potential jurors and then discuss them, the ones that want to be excused, in front of the attorneys, right? MBing said, does the defense have to have a basis for a motion to dismiss the death penalty? See, that's the kind of question I think better suited for an attorney. I don't want to speak on something I'm not an expert on. However, with the 2 reasons they gave, I don't know. It doesn't seem so. But I don't know the answer to that. That would be the responsible way to answer that question. Nice to see you.
Potential jurors, and what I'm doing is not excusing anybody at this point. I'm the commissioner, jury commissioner is just collecting those, and then we're going to do those excuses on the record with you. Okay, I think that's appropriate in a case like this. Does that make sense, Ms. Taylor?
The excuses are from potential jurors who are not needed.
They may be needed. I mean, these are expanding the panel. Okay, because I was thinking that I need a lot more potential jurors to show up.
This audio.
Excuse.
You hear the audio. It comes and goes. It's mono, then dual. Oh, man. Bridget Hart said, so it seems the defense, the genealogist, right? The expert blabbed to a few people that she really didn't agree with some of what she said in her email to the defense. So the FBI had to go see her and find out what's going on. That's what it seemed like. Just to verify, like, whoa, you know, what you testified. That's what you want to say, right? So, yeah, they just had to go and check there.
I never thought I'd actually face that. I mean, I don't think I could be a juror in this case.
I would agree with Your Honor that the image of the court going from the jury box, that just,
It's entertaining.
it is. But I understand and I would have no objection to the court.
Thank you. I thought about that, like going back and forth. I might get tired. But, Mr. Thompson?
It makes perfect sense for the court to excuse itself.
It's odd, but it is logical. But I felt kind of awkward thinking that I would do that, you know, to everybody around me.
We would not want to confuse with pardoning yourself, though.
Right, of course. Always with an open mind.
Yes, sir.
All right. Anything else we need to address today? Ms. Taylor?
No, Your Honor.
Mr. Thompson?
No, sir.
All right. Well, thank you all, and have a good rest of your week. Richard.
And where did they go? And then he's going to smile at the security now. There you go. I'm not such a fan of analyzing his every move, but that security guy was staring at him there for quite a while. And then when Kohberger gets up, he's like, okay then. And that's it. So that was the hearing. The scheduling conference that happened yesterday that really changed everything. So I'm just quickly going to show you this one again, just to remind you. Also, JW said the DP is by statute, and Taylor came up with a motion that says BK is forced to choose between speedy trial right and effective assistance of counsel due to the death penalty. Not a strong argument, but creative. That's what I'm gathering, that they the defense comes up with a lot of creative. I mean, that's their job. Their job is to defend their client, but it's been interesting so far, right? Even the grand jury indictment, the motion they filed to basically have that thrown out was interesting. Very interesting. Sasha, we've gone through it before if you guys missed it. Sasha said, thank you, Grizzly, for all your fantastic work for us. So proud to be a member here and Patreon. Oh, thank you so much. Okay, so I just want to, I won't read this whole thing. I just want to skim through it so that you can see just quickly what was going to happen, just so that you can see maybe the types of things to expect going forward. It's not these dates at all, but you see, this is what was going to happen. There was a status conference, okay, on August 23rd at 2:15 p.m. And then after that, the hearing on the defendant's motion to dismiss the indictment will still be held. I don't know if other things are going to be discussed on that day, but on September 1st, 2023 at 1 p.m., any additional motions regarding the dismissal of the indictment are due by August 23rd. See, they talked about additional motions and now changed the course of the entire trial. The state's response briefing is due by August 30th. So there were a lot of deadlines set. Of course, Kohberger had to come up with his alibi by, I think it was, it's somewhere here, September 8th or so. The point is, you can see, then they said a jury trial October 2nd, no longer. Jury selection, no. So now what's going to happen is that September 1st one, and then they've got to decide on all these other ones, the pre-trial motions and all the other motions to discuss and more hearings, and is the death penalty still going to be on the table or not? So many things, okay? So I'm sure we'll still see a lot more hearings. So another thing I wanted to show you was this one while we're here. So just in layman's terms, the capital murder trial for Bryan Kohberger, the man accused of killing 4 Idaho college students last fall, will be delayed indefinitely. Kohberger's trial has been set to begin October 2nd, less than 6 weeks away, but now will be postponed after he waived his right to a speedy trial Wednesday afternoon in court. The judge accepted his waiver. Kohberger's defense attorney Ann Taylor said more time was needed to effectively present their case than would be possible by October 2nd. The Occult Reject said, Grizzly, love your stuff. I got some Gilgo Beach drone footage this week for you if you still want to keep killing it. Thank you so much. Yeah, you could send it to grizzlytruecrime@gmail.com if you are able to. That's pretty cool. Okay. And so, yeah, there he is smiling. Kohberger's defense said they still wanted to keep the upcoming September 1st hearing to address their request to dismiss the indictment, and after that reconvene to discuss a new schedule reset. So it's like a total schedule reset, including the trial date. The decision to delay the trial had been anticipated for weeks. They caught us, you guys, because we thought, no way, this is not going to happen. This is not going to happen. On October 2nd, a death penalty trial, so quick. But then it was like, after that big hearing day, remember with the 6 motions, we were like, oh, okay, so it is going to happen. And then, nope, just a few days later, taken away. Now it's not going to happen. So I was saying earlier on Patreon, I could say I told you so, you could say I told you so. We can all say to each other, because we actually knew it in our gut. This is not going to happen on October 2nd, right? Anyway, so they say ever since prosecutors announced that they would seek the death penalty against Kohberger in court on Wednesday, Judge John Judge, that is his name, directly confirmed with Kohberger that no one had pressured him in this decision to waive his right to a speedy trial, and that this was what he wanted to do, which Kohberger affirmed. He said, absolutely. Okay, he didn't just say yes to that question. He was like, absolutely. Idaho law requires that defendants receive a trial date within 6 months of their arraignment if they don't waive that right. Okay, so let me just finish it while I'm here, then I'll show you one more thing. Prosecutors allege that in the early morning hours of November 13th of 2022, Kohberger, a criminology PhD student at nearby Washington State University, broke into an off-campus home and stabbed to death 4 University of Idaho students: Ethan Chapin, 20, Maddie Mogen, 21, Xana Kernodle, 20, and Kaylee Goncalves, 21. After a 6-week hunt, police zeroed in on Kohberger as a suspect, saying they tracked his white Hyundai Elantra and cell phone signal data and recovered what authorities said was his DNA on a knife sheath found next to one of the victims' bodies, or just under, right? Kohberger was indicted in May and charged with 4 counts of first-degree murder and 1 count of burglary. At his arraignment, he declined to offer a plea. Remember that? He stood silent. So the judge entered a not guilty plea on his behalf. If convicted, Kohberger could face the death penalty. Okay. Goncalves' family, Kaylee's family, responded to the developments on Wednesday, saying in a statement, upon the court finally putting hard deadlines in place for the family, suspected that the defendant would waive his speedy trial rights. This case carries enormous weight for the families and the community, and this additional time allows both sides to be fully prepared for the next trial date. Okay, that was a good response. And then this one, everybody's talking about this, where they say Bryan Kohberger booted from police program after complaints from classmates. So this just adds to, I guess this would go in the speculation corner. But they say the University of Idaho murders suspect Bryan Kohberger was allegedly kicked out of a law enforcement vocational program in high school. So it's not the one where he applied in Washington to be part of the police department for an internship. This is already in high school. Okay, so they say he was kicked out of a law enforcement vocational program due to complaints from female classmates, a school official claimed. Former administrator Tanya Carmela Beers revealed that Kohberger was briefly on the protective services track at a vocational school near his parents' Monroe County, Pennsylvania home. He was a leader in his class. He took the class extremely seriously, Carmela Beers told the Idaho Massacre podcast. So I've listened to that. I'll link it in the description for you. This podcast and that episode where you can listen from about 10 minutes in or so. Okay. So then they say he took the class very seriously. This lady also said it's all he ever wanted. So when he was kicked off, it was very, very bad for him. But I wonder what he did. So they say a photograph from Kohberger's high school yearbook shows the then sophomore dutifully completing a fitness set as part of the pre-professional course. But now, Kohberger was forced to leave the program in his junior year following a series of complaints from female classmates. I wonder what, again, we've heard about the complaints of female classmates even at the university when he was a teacher's assistant. So that behavior, if this is true, the behavior is very consistent and he seems to be not very nice to women. Okay. To be removed from a program, it has to be pretty severe, Carmela Beers said of the incident, though she declined to elaborate on the exact nature of the reports. What had him removed from the program, when I look back on it now, makes sense with what happened later, she recalled, referring to the bombshell allegations that Kohberger murdered 4 University of Idaho students. Kohberger transitioned to the HVAC program, but ultimately decided not to return to the vocational school for his senior year, Carmela Beers stated. He finished his high school degree online in 2013. The Idaho Statesman reported earlier this year. Kohberger's awaiting trial, as we know, right? So, yeah, here's a picture of him again. We've looked at this before. So they say around the time he was dismissed from the law enforcement program, Kohberger lost a significant amount of weight and morphed into a more dominant, bullyish personality, some hometown acquaintances told the Idaho Massacre team. The schoolyard outcast also allegedly developed a heroin addiction and went to rehab at least once. In the wake of his arrest, former classmates remembered that Kohberger was smart but slightly odd, particularly around girls. If he was liked or was interested in a girl and she wasn't, he didn't understand why, or just didn't accept her saying no and move on, and so he would have been labeled as a creep or something along those lines. Stalker style. Entitlement. My word. Just a few months before the murders, Kohberger also allegedly broke into a female colleague's home. Remember that? Dateline said. You guys remember that? Sometimes when we read over this, I'm like, oh yeah, I remember that. Kohberger's trial is now not set for October 2nd. Off the table. So, but I just wanted to read that to you so that we have also gone over that. Okay, well, that's it for today. We could be here all day discussing lots of little updates. But today, the most important thing I wanted to bring to you was everything that we heard from the scheduling conference and what it means, you know, based on what we know from the public, like what can we expect next? So no trial October 2nd. It's almost like imprinted in my mind, like October 2nd to November 17th. I knew what we were going to be doing. Okay, that's not happening anymore. So I was ready. I was bracing myself. Okay, like, phew. especially with the cameras that were going to be in the courtroom and film the day, but then only release the footage later. That was going to be quite interesting. It still will be if it happens, and let's hope there will be cameras in the courtroom. It would be interesting to see what goes on there. But, of course, if they decide not to, I will understand as well. Aaron, oh my goodness. Aaron, you've been a member for 18 months. Oh my word. That is so cool. You're an OG. Thank you so much. Okay, so thank you so much to all the mods. I'm going to rewatch now so I can see the live chat replay just to see what did I miss. Okay? Hope I didn't miss much. I'm also going to, if you get a notification now, you'll see the video that I'm going to upload, which is a clean copy, a little intro, and then a clean copy of what we just discussed, so that you could just watch it there if you wanted to. Well, soon, not like now. Okay, in the next 24 hours, you should get that, and then I'll keep you posted on all the other stuff, all the other cases we're following as well. So thank you so much to my mods, to all my patrons, to my members, to everyone that subscribed today. I hope that you enjoy your time here with me on this Thursday. Tomorrow's already Friday, and I'm sure I'll see you again either later or tomorrow, whenever. So make sure you are subscribed, hit the bell so you don't miss out when I next upload or make a YouTube short or a live stream or a video, whatever it is. Okay. So looking forward to read your comments as well. Please leave a comment below so that I can see what you guys are thinking. What do you think about the scheduling conference and what's happening in this case? And be careful of the content you consume, because this case is already gone. It took a left turn to Crazy Town a long time ago because it's already gone on for quite a while. So now really like a lot of theories come out, and theories they can be interesting, but sometimes it goes to like really crazy town. Okay, so just be careful, just stay sane. Stay in the sane lane. Okay. Okay everyone, I'll see you later. Bye.